All right, everyone, please be seated. All right, good morning, everyone. All right, it's not that bad. Okay. Everybody with the slow reaction time. Good morning, everyone. All right, this is, yes, yes. So Deputy Laura will take up Ms. Harrison.
Yes.
Okay. And Rick, can you let them know that she's ready to be sworn in? The clerks. All right, thank you.
Oh, they're coming. Okay, sir, if you can have a seat. Judge, do you want him to wait here just in case?
Yes, he can just wait there.
Right.
Deborah, I thought your son would be here.
No, it's just me.
Hey, that's okay. No.
You're stuck with me, at least for today.
Well, I've known you longer than I've known him.
I do have a motion to let me get on. Yeah.
Well, with regards to the motion in limine, I don't know anything about your case unless it's something that is necessarily based in law. My ruling will be, if there's something that, a question related to that motion in limine, just approach beforehand. Or is there something else about your,
We're requesting that no 404B evidence be brought. That wasn't, we requested it in writing, we didn't get anything.
Mhm.
There's some unsubstantiated previous assaults with a different person that are in discovery. I didn't want that coming in because it's not relevant.
well, I don't see how that would come in during the first phase of the trial.
I'm just asking if you want to be.
Well, I mean, before you all ask any questions about that, just approach. Is there an application? Yes.
Did he stay over there? Okay, so.
Mr. Guerra's right there.
Oh, can you
I'm
read
here.
the paperwork on Gara?
She's. I didn't know if you needed information.
Yes.
All right, the court is calling 2024 CR 6410, State versus David Gara. Can I have parties announced for the record?
Mr. Guerra.
And are you Mr. Gara?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Gara, did you review the application for community supervision with your attorney? Did you understand it? Did you review the true bill of indictment with your attorney?
Yes.
Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented? All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right. The state is proceeding as a terroristic threat as a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does.
Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Guerra, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a US citizen, by entering into this plea bargain agreement, you could be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargaining page with your attorney? Did you understand it?
Yeah.
According to the plea bargaining agreement, the state is proceeding on the lesser included offense of terroristic threat. The punishment is to be assessed at 1 year in the Bexar County Jail. There's $1,000 fine. There's no application for deferred adjudication, and the state recommends community supervision. Did you understand that to be your plea?
Yeah, I'm done.
Defense, is that the plea?
It is your honor.
State, is that the plea? Yes.
Seniors in a while, and I just remembered the subsection that was called in the to it's not, I need to consider this punishment, the up to 6 months.
Okay.
Yeah, up to that. And then as part of the agreement, the underlying makes the changes.
All right. Any objections to those changes? All right. So your range of punishment is anywhere from anywhere from 180 days in the Bexar County Jail, 0 to 180 days, and up to a $2,000 fine. Did you understand?
Yes.
All right. According to your plea bargain agreement, then punishment is to be assessed at 6 months in the Bexar County Jail. There's $1,000 fine, and the state recommends community supervision. Did you understand that? Counsel, did you understand that to be the plea? Defense? I'm sorry, state?
Yes, Your Honor.
All right, did you review the waiver? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions? Outside the agreement, the state is recommending your community supervision be for a term of 2 years. There be a TAP evaluation, 150 hours community service restitution, no contact with Todd Hill, the terraces at Haven for Hope, and hostility management course. Did you understand?
Judge, he does live at Haven for Hope right now. This year's homeless.
Well, they're saying that he's not to have any contact at 703 North.
don't go there. I go along the streets.
Okay,
He won't hurt you.
so do you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the lesser included, how do you plead? Guilty, not guilty, or no contest? State any evidence.
It offers states one at a time.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand it? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, we are, Your Honor.
Anything you wish to say on behalf of your client?
That's well, findings on SSI. And it's basically, that I told him, saying that Haven for Hope. He does volunteers a lot there doing, odd jobs and things.
All right, the fine will be probated. Court is going to sentence you to 6 months in the Bexar County Jail, probated and suspended for 2 years. There's a regular reporting by Zoom or in person, $1,000 fine that will be probated. Regular random UAs. Proof of employment or SSI within 45 days. No employment as a home health care provider or with minors. No unsupervised contact with minors. Field visits 1 time per month until further notice. No contact with Todd Hill and the terraces at Haven for Hope located at 703 North San Marcos, San Antonio, Texas. 78207. 150 hours community service restitution. I'm going to order the hostility management course. Once that's completed, the community service hours will be deemed satisfied. MIC evaluation out of custody. Is there anything else that you require from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's plea bargaining agreement, because I followed your plea bargaining agreement, because you waive your right to appeal. Do not have the court's permission to appeal. Do you understand? All right, good luck to you, okay?
Thank
All right, remain outside in the hallway. Probation will go over
Oh.
conditions with you, okay?
Thank you.
All right, thank you.
Thank you.
Are they ready with Richardson? Has she been sworn in?
Harrison. Harrison.
I'm sorry, Harrison? Yes. Oh, sure. Hi.
You done?
All right. All right, thank you. Okay. All right. Oh, thank you. Mhm. Oh, that is so awesome. Mm. All right, thank you so much. Yes. Okay. Okay, if you could do me a favor, because we're bringing a jury in, if you could just zoom in and we'll take care of it. Yes. Mhm. Thank you. Yeah, and it's 10. Well, it's 11. Okay. All right, see y'all back at 1:30. All right. Could you have the jurors come in? Oh, I'm sorry, just 1 second. Has she even been sworn in? All right, just counsel, we'll bring you back at 1:30. They're gonna swear her in next door. Let's bring the jurors in.
I don't know if I have one hand up there. Oh, not by 8. Sure. We'll be back.
All right, thank you.
Thank you.
Ready, Judge?
Yes.
Where's number 10? Back to your job? Okay, come on.
All
Let's
right.
go. Number one.
Try this again.
Try this again. First row. On the second row. Yes, it's on the bench.
Okay.
Anyway, 22, next row. And just pick up that note, Mike, put it on top.
All right, if everyone please be seated. All right, everyone, good morning.
Morning.
Thank you. For some reason, it pops up. Something's wrong with the screens today. All right, everyone. You are in the 187th District Court. You're on the fourth floor. I am Judge Boyd. So what courtroom are we in? What's the floor? Who's the judge? And you always ask, why would she ask us that? We know where we are. The reason why I do that is because sometimes we take breaks, and when we take breaks, people tend to get lost, and then the deputies have to try to find people, and they're trying to be selected on another jury. So if you ever get lost, if you remember the 187th, people will be able to tell you where it is located. There's only one 187 District Court in all of Texas. And if you can't remember that, if you remember Boyd, I'm the only Judge Boyd in this courthouse. Now, to my left is the court reporter. Raise your card. We're going to practice raising our card. Raise your card if you want to make her life difficult today. All right, number 19, you jumped the gun. So this is how we make her life easy, or I should say easier. The tone I'm speaking in, you need to speak at this tone. The pace I'm speaking at, speak at this pace. One person talks at a time. Do not talk over each other, because she has to take down everything that everyone is saying. And we want to make her job easy today. Let's make that a Christmas gift to her. Now, this is a criminal court. This is the state of Texas versus Duran Evans. Could I have the parties introduce themselves for the state?
Morning, everyone. My name is Rick Penny with the District Attorney's Office.
Hello, I'm Ashley Jones.
Good morning. My name is Hugo Sanchez.
And for the defense?
Morning, my name is Sid Grugia, I'm representing Insurance.
My name is Deborah Heinrich. I too represent Mr. Evans. Good afternoon.
And Mr. Evans, if you would introduce yourself. Thank you. All right, so sometimes you're going to see other people in the courtroom. People who come through that door did not read the sign that said, "Do not come through this door, we're in jury trial." People who come through this door, those are for things for me to sign. It has absolutely nothing to do with this case. Legally, courtrooms must be open to the public. So sometimes when you have someone who's accused of an offense, they may have relatives who come in, other people may come in. Does everyone understand? So we have someone else who's here, and if you could introduce yourself.
I'm Neosha Evans, wife of Duran.
All right. And then sometimes we may have students come in, sometimes people who are seeking to become court reporters, and they will practice. But what I can tell you is the official record is through the court reporter we have assigned to this court, and that's with Cindy. With regards to your cards, whenever you have a question, raise your card, wait to be addressed by your card number. That's how the parties will address you. Now, you've had a chance to see all of the parties. Raise your card if you recognize any of those parties. All right. Now, in this case, the charge is assault choking. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and possibly probation. I will speak more to you about the ranges of punishment. Now, what I can tell you is the state, the defense will not be able to tell you what they think the facts of this case are. Anytime they speak to you, it will be done in hypotheticals. So don't be like Mrs. Kravitz from Bewitched and saying, "Oh, those are the facts of the case." The only way you will know what the facts are in this case is if you are selected to be on the jury. Does everyone understand? Now, with regards to indictments, Mr. Evans is here under indictment. What does that really mean? And what is an indictment? An indictment is just a piece of paper to tell somebody what they're being accused of and where they need to be to answer for the charges that they're being accused of. It is not evidence of anything. It cannot be taken as evidence of anything. Does everyone understand?
Yes.
For example, and Cindy, I'm going to see if we still have bad drivers, because so far every jury has a lot of bad drivers. Raise your card if you've ever had a traffic ticket. Don't be shy. I think the statute of limitations have ran. So, all right. Oh no, raise them high. All right, you can lower them. So I've had a traffic ticket before once in my career of driving. I was probably about 19, 20, 21. Here I am, 2022. Have not had another. Thank you. See, I'm seeing if people are awake. So when I received my traffic ticket, it was back in the day where they had the carbon copy. The officer would write it down. You would have different ranges of what the punishment would be. You know, send in $100 or either come to court. So hypothetically, let's say you get pulled over and the officer pulls you over and the officer says you ran a stop sign. I think now they do some kind of electronic thing, but they'll give you a ticket. You will receive the ticket. What is on that ticket? Usually what will be on that ticket is the officer saying you ran a stop sign, and it will have ranges of punishment on there and where you need to go to answer. So when you accept that ticket from that officer, you're not saying, "Officer, yes, I ran the stop sign." You're accepting that ticket so you can have notice. It would be odd if you accepted that ticket for running a stop sign, and then when you get to municipal court on Frio, they say, "We got you, surprise. We're actually charging you with running a red light." You wouldn't be prepared for that because you thought it was a stop sign. So that ticket is not evidence of anything. It's just to let you know what you're being accused of and where you need to appear if you want a trial. Does everyone understand? And it's the same thing with an indictment. An indictment is just to let somebody know, this is what you're being accused of. This is where you need to appear if you are requesting a trial. and you cannot consider it whatsoever for any purposes. Everyone understand? Is there anyone here who's going to hold it against Mr. Evans because he's here under indictment? Now, the next thing I want to talk to you is about the right to remain silent. Everyone who's accused in a criminal proceeding has a right not to testify. What does that mean? That means that the state can't call someone who's accused to testify. There are many reasons why somebody would choose not to testify. I've been a defense attorney, I've been a prosecutor. Sometimes I would have a client as a defense attorney and I would say, look, you're nervous talking to me in the office and I'm on your side. You would not do well in front of a jury. And it had nothing to do with whether they were guilty or not guilty. It's just that people are afraid of public speaking. Sometimes I would have clients who would have speech impediments. Sometimes I would have a client, I would tell them, state and prove their case. There's no need for you to testify. The key is to that is everyone has a right not to testify. And some people will say, well, if that were me, I would testify. And I always laugh about that because I always tell people, yeah, you don't have an attorney who's maybe advising you, and it's not you. But the key in this case is that if Mr. Evans decides not to testify, you can't hold it against him. You can't consider it. Does everyone understand?
Yes.
Is there anyone who's going to hold it against Mr. Evans if he decides not to testify? What's your number?
28.
All right, you need to turn your card around. No, your number,
Oh, I'm sorry.
my vision is not that great. Thank you. And here's the other thing. To make Cindy's job easier, raise your cards for me for a second, please. When I ask you to lower your card, lower your card. Jurors 1 through 21, lower your cards. Everyone else with the cards 1 through 21, lower your cards. Everyone else who has your card up, in order to make Cindy's job easier, whenever you're answering a question, I'm going to need you to stand because the acoustics in this courtroom is not great and she'll be able to hear you. Can everyone do that for me? All right, thank you. Now, the next thing I want to talk to you about is presumption of innocence. Everybody who is charged with a criminal offense and goes to trial is presumed to be innocent. In law school, this is how they would make us understand it. So I'm going to give you this example. At the defense table, they could play crossword puzzles. They could do games. They could not pay attention to what's going on in trial. You know why? Because they don't have to prove anything and their client is presumed to be innocent. They don't have to present any evidence. The state has the burden to prove anyone who's charged with a criminal case. They have to prove the elements of their case beyond a reasonable doubt. Does everyone understand? So that burden never shifts to the defense. So at this time, as Mr. Evans sit here, you're required to presume that he is innocent of presume that he is not guilty of these charges. Does everyone understand? Yeah. And the reason why you do that is because you have not received any evidence. You don't know anything about this case. Does everyone understand? Yes. So if you were asked right now to vote on whether Mr. Evans were guilty or not guilty, what should your vote be? What should your vote be? All right. Now, burdens of proof. I told you the state's burden of proof is proof beyond a reasonable doubt. What's the definition of it? That does anybody know the definition of that? Raise your card if you do. All right. So I see a lot of people have not watched Perry Mason, The Practice, and Paper Chase. Well, proof beyond a reasonable doubt, there used to be a definition. In law school, you had to memorize that definition. During my very first jury trial as a defense attorney, I knew that definition forwards and backwards. I knew where to put the commas, I knew where to put the explanation points, and I even knew where to pause for dramatic effect. But there is no longer a definition for proof beyond a reasonable doubt. So neither the state nor the defense will be able to tell you what that definition is because it does not exist. So how do you know then what are you supposed to be doing with regards to the burden of proof? I would tell jurors what it is not. Next door, there's the historic courthouse, the one with the green rooftop. They have two burdens of proof over there. One is preponderance of the evidence. What does that mean? That means more likely than not something occurred. If you are ever deliberating in a criminal case and there is a juror who's saying, well, I believe more likely than not that happened, you need to tell them, excuse me, you're in the wrong courthouse right now mentally. You're in the civil court. This is a criminal case. The other burden they have on that side is what is called clear and convincing evidence. Clear and convincing evidence is the type of evidence that's presented to terminate someone's parental rights. They're saying you're an unfit parent. We cannot trust you to raise your child. Does everyone understand? There's a burden that's higher than that burden, and that burden is proof beyond a reasonable doubt. I want to talk to you about fairness because people will ask you, can you be fair in this case? Is this case going to be hard for you? This is what fairness means. This morning, let's say you said, you know what? I'm going to do my civic duty. I'm feeling great about serving on a jury. You map out your plan. You know which routes you're going to take. You've done a test run and you get up extra early, drink your coffee. The birds are chirping. You come downstairs and your vehicle's on cinder blocks. And you're like, curses. But you know what you say? Still going to do my civic duty. So you take an Uber or the Via or your next door neighbor takes you, come down for jury duty. You're standing out in the hallway and you come in and you find out that the charge the person is being accused of is burglary of a vehicle. Now, people will always say, you can't be fair in that. That's really not the proper question. The proper question is, even though that has happened to you, and you realize that this case is a burglary of a vehicle, will you be able to listen to the evidence that's presented to you and make a decision based, if you can, based upon the make a decision based upon the evidence that's presented to you? Or are you going to say, you know what? My vehicle was burglarized. I don't care if this person did it or not. I'm just upset with anybody who's charged with burglary of a vehicle. Does everyone understand? So that's what fairness means. Raise your card if you were born yesterday and you slept all last night. Those are the only people who have not had any trauma, possibly, or anything that has happened in their life. So we all come with experiences, life experiences. But in this case, when I'm asking you if you can be fair, what I'm asking you is, if you're able to come to a decision in this case, will you be able to base that decision upon the facts that are presented to you? That's what fairness is. Is there anyone here who will not be able to do that? Raise your card. All right, the next thing I want to talk to you about is there are two phases to a jury trial on the criminal side. First phase is somebody guilty or not guilty? People always call it the innocence phase. It's not. It's, did the state prove their case beyond a reasonable doubt or did they not? If the state fails to prove their case beyond a reasonable doubt, then the verdict is not guilty and there is not a second phase. If they do not prove their case, if they do prove their case beyond a reasonable doubt, then there's a second phase. And that second phase is what's called punishment. In this case, the range of punishment is potentially probation or anywhere from 2 to 10 years in the prison and up to a $10,000 fine. Now, if you think about that, that's a wide range of punishment because you're thinking 2, 3, 4, 5, 6, 7, all the way up to 10. And people will always say, well, I need to know what the facts are before I'll know what I can give somebody. Again, that is not the proper question. The proper question is, does everyone understand that is the range of punishment in this case? Has everybody internalized that? So what will happen if somebody were found guilty of an offense during the punishment phase of the trial? Facts may be presented to you, and then you'll need to take whatever facts that are presented to you and decide on what you feel is an appropriate range of punishment. Does everyone understand?
Yes.
For example, sometimes people say, you know, I could never consider 5 years for someone who's charged with murder. Let me give you a hypothetical. Let's say someone goes to school, everybody always knew that that child was going to end up killing somebody. They kicked the cat, they tore off the wings of butterflies. And as they get older, there's this little old lady who's walking across the street. She used to be a Girl Scout, used to be a teacher, was kind to everybody, would give the shirt off your back. This person that everybody knew was going to end up killing somebody, he walks up to her, punches her in the face, she falls down, he kicks her till she dies. Now, that may be some person where you say, you know what, that person may deserve life. Another hypothetical. Let's say you have two parents, they always wanted their children to get married, they're constantly putting them together, they put them in the same daycare, the same preschool, they end up being sweethearts. They get married, they have children, they have grandchildren, and they're in their later years in life. And one of them gets ill. And the doctor tells the others, the healthy spouse, there's nothing we can do. They're going to be in a lot of pain, and we really can't comfort them at all. So they go see their spouse, they discuss things, and the spouse said, I'm in so much pain. Could you just help me? You know, could you just give me a glass of water and these extra tablets and help me? Well, guess what? That's murder. Now, in that case, you may say, you know what? I don't even think 5 years is appropriate. But as you can see, that's why you have wide ranges of punishment. And it's up to you to take whatever facts that are presented to you and make a decision. Does everyone understand?
Yes.
Is there anyone here who cannot consider the full range of punishment? The next thing I want to talk to you about is the English language. I love languages. I'm not supposed to be in Texas. I'm originally from Louisiana. You can tell it when I say the words like all and soul. So I should have been retired at 21, living my life in France. So when we had a choices of languages to take, you can guess, even though my friend was begging me, Stephanie, let's take Spanish together. Like, I'm never going to need Spanish. I need my French. And then I go to law school here and I'm working on my Spanish. If my Spanish is not as good as it should be, you can blame the deputies and other people who speak Spanish because they're supposed to be teaching me. So raise your card if English is not your first language. And when I call your number, you can lower your card. 6, 23, 25, 27, 41, 43, 46, 51, 62, 64, and 71. Of those people who are raised your cards, raise your card if your first language is Spanish. All right, that's 51, 27, 41, 43, and 46. All right, those of you who raised your cards, 27, 41, 43, 46, and 51, if you could please stand. All right, number 27, have you been able to understand everything?
More or less.
All right, what does more or less mean?
Well, that I just, I'm hard to hear,
Okay,
but in the way that you're speaking, you know,
all right, thank you. Number 41,
Yes, for the most part, I do have a busted eardrum, so it's a little bit hard for me to hear, but I can understand.
all right, thank you. Number 43,
Yes, ma'am.
thank you. Number 46,
Yes, ma'am.
thank you. Number 51. All right, number 6, what is your first language? Ah, have you been able to understand everything?
Divorce.
You mean the legal terms?
Yeah.
All right, thank you. That'll be explained to you. Number 23,
Living.
and what is your first language?
Vietnamese.
All right, thank you. 25, your first language?
Spanish.
Have you been able to understand everything? All right, thank you. Number 62,
And German.
have you been able to understand everything? Thank you. 64,
It's Russian.
have you been able to understand everything? Thank you. 71,
Yes, I understand.
all right, thank you. All right. I expect this trial to probably conclude by Friday. Is there anyone who have any time constraints? And by time constraints, I mean that you have non-refundable tickets somewhere. All right, 37. Anyone else? All right, 37. What is your time constraint?
On Saturday morning, I'm flying out.
Oh, where are you headed?
Down,
What are you doing in Dallas?
seeing family.
Do you want to see them?
Yeah.
Right. Sometimes you don't. All right. 73. You need to stand.
I leave out in the morning.
Where are you headed?
I'm headed to Laredo. I'm a truck driver.
All right, thank you. 74.
Is this just for tickets or if there's another issue?
What is the other issue?
I start a series of knee injections tomorrow
And what time?
at 1 o'clock.
All right, thank you. 72.
I have a surgery scheduled on Friday morning.
What time?
9 a.m.
All right, thank you. Anyone else? All right, see, I asked this question. Now people see nothing bad is happening to people when they tell me. Number 6.
Yeah, I have a dentist appointment tomorrow in the afternoon until.
All right, thank you. Number 52.
My mother has a medical procedure tomorrow morning at 7.
All right, thank you. 54.
Heart issues. I have a echocardiogram on Friday.
Okay, thank you. 69.
My uncle's burial and funerals.
I'm sorry, what?
My uncle's burial and funeral is Thursday and Friday.
All right, thank you. I'm sorry to hear that. Anyone else? All right, so this is what I'm going to do. I'm going to give you all your lunch break now, and we're going to come back at 1:15 to conclude with jury selection. I'm going to need you to leave your cards on the seats, and you're going to make sure that you're lined up outside at 1:15. Look to your left, look to your right. You're responsible for that person, and you need to be lined up in the order that you are now. All right? All right, thank you.
Another, please.